बिस्मिल्लाहिर्रहमानिर्रहीम। अस्सलाम वालेकुम। सिविल लॉ साइटेटर में खुश आमदीद। और आज की टॉपिक है एफिडेविट। इससे पहले 6 और टॉपिक मैं कवर कर चुकी हूँ जो आपको चैनल की प्लेलिस्ट में मिल जाएंगे। रेलिवेंट प्रोविजन है जिसकी हाई कोर्ट रूल्स एंड ऑर्डर वॉल्यूम 4 पार्ट बी चैप्टर 12B रूल्स 8, 9, 14 एंड 15 एज वेल एज सेक्शन 139 CPC। बेसिक रिक्वायरमेंट्स। The main requirements of affidavit as per High Court Rules and Orders Volume 4 Part B Chapter 12B Rules 8, 9, 14 and 15 are name of the court and the title of the proceeding, subject of the suit or proceeding, name and deponent, the date and place. The affidavit is to be divided into paragraphs which shall be numbered consecutively and shall be confined to distinct portion of the subject. The deponent other than the party to the suit shall be described in such a manner as would serve to identify him clearly, i.e. full name, father's name, profession or trade, and place of his residence. The declarant in affidavit will referring the facts within his knowledge must do so directly and positively using the words I affirm or I make oath and say when making reference as to information obtained from others. The declarant must use the expression I am informed and should and verily believe it to be true, or he may state that sore e form which he received such information. Every affidavit shall be signed or thumb marked and it shall be verified in accordance with the verification in the forms given in Rule 16 of the High Court Rules and Orders. The verification shall be signed, thumb marked by declarant. The affidavit shall be attested by the ओथ कमिश्नर। ये है जी एफिडेविट जिसे हम बयान हल्फी कहते हैं। उसका पूरा का पूरा प्रोसीजर, उसमें क्या क्या चीज़ें लिखी जाती है, नेम लिखा जाता है, उसका टाइटल लिखा जाता है और एफिडेविट को पैराग्राफ में लिखा जाता है। डिपोनेंट जो है वो अगर वो पार्टी टू सूट के अलावा है तो फिर उसकी पूरी डिस्क्रिप्शन लिखी जाती है और मतलब जिस टॉपिक जिस हवाले से उसने वो देना है एफिडेविट बयान हल्फी तो वो उसकी सारी डिस्क्रिप्शन लिखी जाती है। और उसके अलावा जो डिपोनेंट है वो क्या कहेगा कि आई अफर्म, अगर उस वो खुद अपनी स्टेटमेंट बताता है तो फिर वो कहेगा कि मैं, जिसे हम उर्दू में लिखते हैं कि हल्फन बयान करता हूँ इस तरह। लेकिन अगर वो किसी और की स्टेटमेंट बता रहा है तो फिर वो कहेगा कि आई इन्फॉर्म्ड, और फिर साथ ये भी बताएगा कि मुझे उस बात के यकीन पे यकीन है कि वो सच है जो भी बता रहा है वो। और उसके अलावा इसको वेरीफाइड किया जाएगा और थंब इम्प्रेशन लगाए जाएंगे उसके। द एफिडेविट विच लैक्स एनी ऑफ दीज पार्ट्स इज़ नॉट एन एफिडेविट इन द आई ऑफ लॉ। अगर एक भी एलिमेंट कम है तो वो एफिडेविट नहीं है। PLD 1995 लाहौर 98। सर्टिफिकेट ऑफ ओथ कमिश्नर। एफिडेविट डिड नॉट बेयर रिक्वायर्ड सर्टिफिकेट ऑफ ओथ कमिश्नर सर्टिफाइंग दैट कंटेंट्स ऑफ द डॉक्यूमेंट्स वर स्टेटेड ऑन ओथ or solemn affirmation before him by deponent and that the deponent was either personally known to him or was identified before him by a person known to him. Oath commissioner without such certificate and without appearance of the deponent before court, the affidavit could not be deemed as an affidavit in the eye of law and no legal value in circumstances. 2003 CLC 44. Affidavit not in prescribed form. Even if an affidavit is not in the prescribed form and the deponent enters in witness box on oath and presents himself for cross-examination, then the affidavit is taken as a written examination in chief of the deponent. 2016 CLR 1475. Purpose of attestation and affirmation of oath. A person cannot administer oath to himself. The object of an oath is that there will be a superhuman retaliation in case of falsehood, and the purpose of giving oath is to confront a party to the Almighty Allah. Therefore, somebody has to attest or affirm that the oath was made by the maker thereof. Section 139 of the Code of Civil Procedure refers to an affidavit by the heading of this section. Is oath on affidavit by whom to be administered? It is not an affidavit of a person which is required to be attested by person mentioned in section 139 of the Code of Civil Procedure. It is in fact attestation of the oath on affidavit 2004 CLC 914. Again, the difference between section 139 CPC and order 6 Rule 15(1). Section 139 CPC deals with the affidavits and not with the verification of pleadings and documents, while Rule 15(1) of Order 6 CPC deals with the verification of the pleadings and is not required to be attested by oath commissioner. The rationale in enacting this provision seemed to be that the pleading and documents appended therewith should be prima facie made authentic, because these anything being false in the election petition or any document being forged or fabricated, the party at fault could be punished by the tribunal or concerned court itself. 1999 MLD 1533. Verification is not proof of pleading. Section 139 CPC is to be read along with the Order 19 CPC pertaining to the powers of the court to order proof of acts by an affidavit. The verification is neither evidence nor proof, and simply because the pleading is verified does not convert it into proof. 2005 MLD 1577. Section 139B of the CPC provides for an oath commissioner having to administer oath to a deponent. Not only that, none of the so-called affidavits appears to have been sworn before any oath commissioner, but also there is no certificate to such an effect appended on either of them. 1987 MLD 1372. Statement in affidavit is not substantive evidence. It is settled law that the statement in affidavit cannot be treated as substantive evidence or acted upon unless the other party has had an opportunity to cross-examine the deponent, except its interlocutory proceeding, and as such the trial court was plainly wrong in taking such statement into consideration. 1997 MLD 2835 कराची। मतलब यह है कि एफिडेविट के ऊपर हम जो दे देते हैं बयान, तो वो कहते हैं ये जो है प्रूफ हो गया कि उसने हल्फी बयान दे दिया, लेकिन ये प्रूफ नहीं होता। इसके ऊपर दूसरी पार्टी को क्रॉस का राइट होना चाहिए, वो क्रॉस करे उसके बाद फिर ये प्रूफ होगा। इफेक्ट ऑफ नॉट कंपाइलिंग प्रोविजंस ऑफ ओथ। ओथ हैज़ नॉट बीन एडमिनिस्टर्ड to appellant by a person authorized to do so as per requirements of Order 6 Rule 15 read with Section 139 CPC. Thus, the pleading shall be deemed not only verified on oath. PLD 2007 Supreme Court 362. Section 139 CPC provides that any affidavit under the code has to be sworn on oath, which is to be administered by persons mentioned therein, and that Rules 2 and 6 Chapter I 1E High Court Rules and Orders Volume 5 lays down then that an application for admission of an appeal, which is prima facie barred by time, has to be accompanied by affidavit, oath of which had to be administered by a person appointed as provided under Section 139 CPC. C. Affidavit accompanying this application having been just attested by a commissioner of Rath, Kent, UK, and the same having not been authenticated by an officer of the Embassy of Pakistan there, wherein the officer is appointed to administer oath, has no value, and there was no properly constituted application filed with the appeal seeking condition of delay application under Section 5 of the Limitation Act being not maintainable in view of the provisions of Section 139 of the Code of Civil Procedure read with High Court Rules and Orders mentioned above also has force 1979 CLC 725 Lahore. Whether statement of person who filed affidavit but does not face cross-examination can be referred in judgment. If a person filed his affidavit but did not face the rigorous of cross-examination, he cannot be termed as a witness, and his statement cannot be referred in judgment as statement of PW 2018 YLR 1262। अगला टॉपिक जो है वो ADLR का, वो नेक्स्ट टॉपिक में करेंगे। थैंक यू सो मच फॉर लिसनिंग। अल्लाह हाफिज़।